Okay, well, welcome to contracts again, remotely in coronavirus time. I am going to record today some comments on the March 16th syllabus provisions, which is really it's captioned contract dispute resolution. And we'll be talking really about arbitration today. There are two other classes, the March 23 and March 30, on assignment and third-party issues coming up. I will try to record those next week and watch them, and then we'll just have to figure out whether we can do a review or not, and if so, how we can do it. Obviously, everything is changing day by day. My office is working remotely this week. That's why I'm casual today, and so we're just doing the best we can in a strange situation. I do want to remind you all that the exam is scheduled for April 27th, and remember I told you all that you could bring one piece of paper, one 8.5 by 11 piece of paper, front and back, covered with whatever you want to put on there in terms of notes or outlines, material. That's the material you can use for the exam. It's not generally an open book exam, but you do have the option of taking in those notes with you to the exam. You can email me if there are questions about that, but I think we've talked about that before, and you all should understand that. So the topic for today is really arbitration, alternative dispute resolution. There are multiple methods of alternative dispute resolution, and I think the reason we are focusing on arbitration is that it is a creature of contract. And so it's appropriate for discussion in a contracts course. As the materials remind you, we've actually seen a number of arbitration provisions in other cases that we've studied this year. So it's not a totally new concept, but exactly how it works, and in particular, how the United States Supreme Court has been treating arbitration in very recent years is highly relevant to what we're talking about. Before I talk too much about the specifics of arbitration, there are other methods of alternative dispute resolution. The other most prominent one, I would say, is probably mediation. And many of you, I'm sure, know that mediation is a voluntary process. It's also something parties do by agreement generally. And in that process, folks hire a third-party neutral mediator to help them try to settle their case. The big important difference is that a mediator does not have the power to adjudicate a dispute. So all the mediator can do is suggest resolutions, suggest comments, suggest strengths and weaknesses, and try to help reach a resolution of a case. But if a case doesn't settle at mediation, there's no power of a court to enforce a process or to force a settlement. There are certain cases now, certain instances now where courts will order parties to mediate, but even when that happens, even when they do it sort of non-consensually, a court still doesn't have the power to force parties to reach a settlement. Arbitration is quite different. Arbitration is essentially a private, consensual dispute resolution mechanism that is binding and reaches a binding result that can be enforced in a court. In this process, folks will agree to arbitrate whatever dispute they have, and the arbitrator or panel of arbitrators acts like a court to some degree. They have the powers of a court to some degree, but the process is a good bit less formal than court process, and probably the most significant thing about arbitration is that it's generally not reviewable. So the results of the arbitration are binding on the parties, but there's no right of appeal. It's a private mechanism, and I'll sort of go over what I put in my notes. Some of the key facets of arbitration might include. The first is, of course, that it depends on the consent of the parties. There has to be an agreement, a contractual provision to arbitrate a dispute. Next is that it's less formal than a court, so often rules of procedure don't apply, at least they don't apply in with the same formality and the same force that they do in court. The decision of the arbitrator, as I mentioned, is binding, both the factual determinations and the conclusions of law that the arbitrator draws, and there's very limited review of what the arbitrator decides to do. I've actually served as an arbitrator quite a few times. It's a process that's given me a new or a newer perspective on the job that judges have to do in courts, because it bears the responsibility of listening to the proof and reading the briefs, coming up with the right law to apply, and making a decision. So it's quite different from being an advocate, which is what I do most of the time. So I'm going to just go over what the materials tell you are some of the other attributes of arbitration, and these are really found on pages 919 and 920 of your text. The parties can control the scope of the arbitration. That is to say, they can say what disputes are subject to arbitration, what exactly they're going to submit to the arbitrator, and they can choose how to select the arbitrator. Often this is done by referring to rules of arbitration, such as the AAA, which is the American Arbitration Association. I'll talk about that just in a second, because I do have some experience with that. But the control over the scope and the process is generally thought of as an advantage to arbitration. And the less formality and complexity, the second point made in your text, is also thought of as an advantage. That is, that there's not a set of civil procedure rules that apply. It really all depends on the agreement and on whatever protocols the parties agree to adopt. Often the written agreement will refer to the AAA rules or to some other association whose rules might apply. The agreement can sort of describe how that's done, but it's a more fluid process, and it's a less precise process. I can tell you that with AAA arbitration, which I have sometimes participated in as an arbitrator, a common mechanism for selecting the arbitrators is that one side will name one arbitrator, the other side will name the other arbitrator, a second arbitrator, and then those two people named will try to select a third. This is an interesting process because usually the plaintiff party will name someone that they think is going to be sympathetic to their point of view, to their types of issues that they plan to present. And the defendant will do the same, name somebody that they think would be sympathetic to their point of view. It can be a little bit difficult for those two people named to agree on a third. Sometimes they can. If they are able to, then that becomes the third arbitrator, and then you have a panel of three. If the parties can't agree, then under AAA procedures, the AAA picks somebody. The association actually names someone from its panel to be the third arbitrator, and that person is generally the chair of the panel. So it's a process. I mean, the material says attended with a great deal of uncertainty. I would agree with that. It's not nearly as precise as filing a case in court, being assigned a judge, having a certain period for the other side to answer, and so forth. It's quite a bit different from that. The materials suggest that the parties and the arbitrators, or arbitrator, it can be a single arbitrator, will have some control over the duration of the process and how much is done for preparing the case. That's generally true, although it's been my experience that in complex arbitrations, the parties will ask the arbitrator to allow depositions, to allow written discovery, to have hearings, to have dispositive motions, summary judgment motions, and the like, so that there's actually, the case will mimic the progress of a case in court to a large degree. The materials also suggest that you might get some expertise in the arbitrator, whereas in court, you're assigned to a judge who may or may not have specific expertise in the subject matter of the lawsuit. Again, I think that's true. One of the big perceived advantages for arbitration for some parties it would be the confidential nature of the proceedings, and this is an important consideration. In court, of course, matters are subject to, they're all matters of public record. People can come into court and watch proceedings. They can be reported on in the media. They're not secret. They're open, public proceedings, and what's filed becomes a public record. That is generally not true in arbitration. The entire proceeding is private. The materials filed are filed only with the arbitrator, and the decision, when it's made, is generally not publicly available. It's binding only on the parties and is not really of precedential value in other cases. Again, that sort of highlights the last thing I guess I'll say about arbitration, which is that the decision is one just between the two parties or the parties to the arbitration. It's not something that will set precedent down the road. It's not something where maybe the public policy of the decision is quite as significant. And it would be a truism that the materials say a compromise decision is possible, whereas in judicial proceedings it's frequently all or nothing. Again, I think that's true in the experience of a lot of lawyers, including myself, that arbitrators can sometimes reach a result that's somewhere in the middle of the parties' positions. One thing that's not clear from the materials, but that I think is important to know, is that at least under the AAA rules, the American Arbitration Association rules, the parties can ask the arbitrator to simply render a decision, like how much money is due to one party for the breach of a contract or for the alleged breach of a contract. And the arbitrator can simply issue maybe a 1 or 2 line decision about what the award is without explaining. But under the AAA rules, the parties do have the option of asking the court for what the rules call a reasoned opinion. And that's what I have generally been asked to provide when I've been an arbitrator. So there's a little more formality to that. In that mechanism, the arbitrator actually writes an opinion explaining the findings, explaining what facts the the arbitrator has relied upon, and explaining the legal principles that apply to the decision. So I think it's fairly common, particularly in larger cases, for folks to actually request a reasoned opinion. Now, having described all of that for you, or just a general overview of all of that, one of the perceived advantages of arbitration is that it's less expensive than litigation. I think that can be true for smaller disputes. I'm not convinced that it's particularly true for cases that involve more money or more complex issues. My experience has been that parties treat that very much like a real trial, do the work that they would do in a real trial, and present testimony and file legal briefs and arguments very much as they would do in court. I'm not sure that it really is a big cost-saving mechanism, although, again, that's generally thought of as one of the advantages. We've had arbitration in this country probably close to 100 years. It's private dispute resolution. I think when it started, probably it was not very common at all, and courts were hostile to it. Courts sort of saw it as taking business away from the courts, taking something that belonged in the public forum and putting it in the hands of private parties. And there's always a tension for parties who say they've agreed to arbitration as to whether a dispute should be in court or whether it should be decided by an arbitrator. And we'll talk a little bit about that, particularly when it gets into whether the agreement to arbitrate is enforceable or not. But we'll come back to that. So our materials give us several decisions by the United States Supreme Court. about arbitration, about the subject of arbitration. And you can see, starting on page 921, we get a 2008 case in the Hall Street Associates case. This is a fairly run-of-the-mill commercial dispute involving a long-term lease to a manufacturer and whether the manufacturer is responsible for some environmental consequences or conditions of the property that was subject to the lease. It's a dispute basically between a commercial landlord and a commercial tenant. So the type of thing that is often subject to arbitration, and in this instance, the lease here provided for arbitration. The question in the case really is one of policy about the meaning of the Federal Arbitration Act, which I should probably pause and speak of for a minute. I think our materials tell us that that statute was passed in 1925, and it was passed by Congress, the federal Congress, in response to what was perceived to be judicial hostility towards arbitration agreements. And a lot of what we've read in the materials for this lesson point out that the purpose of the act was really to place arbitration agreements on a national level on the same footing as other contracts, that they were not to be disfavored, that courts shouldn't decline to enforce arbitration agreements for reasons other than they might decline to enforce contracts in general. And so it expressed a national policy, I guess you could say, favoring arbitration. And it sets out in the Federal Arbitration Act a process for that, and it also sets up a process for review by the courts, although this is a very narrow review process. And pausing on that for a minute, there's a narrow review process, I would suggest, probably because if you favor arbitration, you want that result to be final and non-appealable. You want the parties to stop fighting and accept the result of the arbitrator. And so, however, if the parties don't accept the result, the party who wins wants to enforce the award just like the party would want to enforce any judicial decree. And so the courts are given power, the federal district courts are given power to enforce arbitration awards as in the way that they would enforce other civil awards in a court. They also have the power to modify or correct an award where there might be a certain circumscribed set of issues for the court to do that. So there is some limited ability of a court to both enforce or to vacate or to modify an arbitration award. Again, those are very narrow grounds that are set out in the statute. And the question in this particular case is that the parties had a bench trial and then agreed to submit to arbitration at the district court level and entered an order in the district court that sort of circumscribed how they would do their arbitration and what kind of review the district court could make of the arbitration decision. And they provided in that, and the trial court agreed, that they could ask for review where the arbitrator's conclusions of law are erroneous. That was the agreement that the parties made. The question then resulted in a lot more litigation because there were arbitration awards, and the question really became, can the parties agree to a different scope of judicial review from the scope of review that is set out in the Federal Arbitration Act? Another way to put that would be, are the grounds of review set out in the Federal Arbitration Act exclusive? And do they essentially preempt the ability of the parties to agree to anything beyond that? In this case, Justice Souter, who wrote the majority opinion, held, and this is on page 923, that the grounds set out in the statute, sections 10 and 11, provide the FAA's exclusive grounds for expedited vacatur and modification. That is to say, the grounds in the FAA are exclusive and the parties are not free to expand the scope of judicial review by private agreement. The court gets there on pages 924 and 925, really with a statutory construction argument interpreting the Federal Arbitration Act, and basically make a textual argument that when certain grounds are listed, it typically excludes other grounds, or certainly would exclude more general grounds. And so the court believes, and this is an important building block for what comes next, that the Federal Arbitration Act provides the exclusive method for a court to review. And those are very, very limited grounds. They're set out in the footnote on page 923, where the award was procured by corruption, fraud, or undue means, where there was partiality in the proceeding, and so forth. So when the process itself is tainted in some way and that can be proved, or where there's misconduct, or where the arbitrators clearly exceed their powers, then a court has the ability to step in and make corrections. But it does not include, particularly, the arbitrator's conclusions of law are erroneous as a ground. So just getting it wrong, getting the law wrong by itself is not a ground for a court to review a decision. This is an important building block for what comes later in the Supreme Court jurisprudence on arbitration, because it's basically saying the policies for how courts view arbitration are set out in the statute, and particularly how a court can review. There is some flexibility in terms of what the parties can agree to in arbitration, how they select the arbitrator, what subject matters they agree to arbitrate. But the ability to get that reviewed in a federal court is circumscribed by the statute and limited to the statute. So that's the first building block. That's the Hall Street. That's the Hall Street decision, and we'll sort of discuss how that plays in down the road with some of these other arbitration cases that we will talk about. I do want to lift up for you all note 1 on page 925 after the case. That's a non-statutory ground that appears to be a judicial gloss on the Arbitration Act, where an arbitrator has manifest disregard of the law. This can sort of be pegged to what's in the statute, I suppose, and the materials say that it has to do with the arbitrator exceeding the arbitrator's powers. That is one of the grounds laid out in the statute. And so if there's manifest disregard of the law, that might be used as a wedge to get a court to review an award. But that was not the case in the Hall Street Associates case. It was simply an argument that the arbitrator got it wrong, got the law wrong, made an error of law. Now, pause there for a minute and realize that submitting your dispute to an arbitrator or a panel of arbitrators is scary that way. That is to say, you do the best you can to lay out the facts for the arbitrator. You do the best you can to lay out the law for the arbitrator. But if the arbitrator gets it wrong, that is not a ground for getting review, which in a court case definitely would be grounds for getting review. Errors made by the trial court and mistakes of law made by the trial court are reviewable in the ordinary course of appeals in a regular civil case. And that's simply not true in arbitration. I think this case, the Hall Street Associates case, again, is a building block in a series of cases that's going to express a policy favoring arbitration, encouraging arbitration, finding that it's easy to find that the parties have agreed to arbitrate, and then a sort of a more hands-off policy of judicial review of arbitration agreements, leaving a lot of things in private hands. So the ability of parties to contract for arbitration is profound. It's a significant, powerful tool that's available to parties if they choose to engage in it. Getting judicial review, this case teaches us, is really hard, really difficult. So again, giving up that chance of review, giving up the ability to correct errors of law, errors of fact or law that are made, is a big give up and a big negative, I would say, towards arbitration in general. The next case from Minnesota, the Michael Curry case, deals with a fairly common conflict that comes up in a lot of arbitration issues. And it basically is where parties have agreed ahead of time to arbitrate disputes. Here it was a clause that was included in a contract, and in particular to an amendment to a contract. And the parties appeared to have agreed to arbitration, but one of the parties claims, wait a minute, the whole agreement was obtained by fraud in the inducement. And so there is no agreement, including no agreement to arbitrate. That's the claim made by the party that wants to be in court after the fact. The other party, the defendant here, says, no, we've agreed to arbitrate, and that includes all disputes, and that would include the question of whether there was fraud in the inducement, and everything, including the validity of the arbitration agreement, should be decided by an arbitrator. And you all can see the importance here, whether a court decides whether the agreement is enforceable or not on the front end, and if it's enforceable, then arbitration would be compelled, or whether it's not enforceable, and then the parties could proceed in court. One party in this instance wants the court to make that call. The other party wants the arbitrator to make that call. And consider how important that really is, because courts are applying general principles of contract law. Courts are skilled in deciding whether contracts are enforceable or not. And arbitrators may really have been hired to think about some other aspect of the dispute, probably the substance of the dispute. Again, this sort of tension between whether the right to compel arbitration is decided by a judge or whether it's decided by the arbitrator is a common dispute. And in Minnesota, apparently, what that court has chosen to do is to look particularly at the language of the contract itself. Now, the court recognizes that when there's an allegation of fraud in the inducement, the whole validity of the contract is in dispute. So it's not just the arbitration clause, it's everything. Did the parties even make a contract? Or would the contract be rescinded based on fraud and the parties would simply not be in a contractual relationship? Understanding that arbitration is only enforceable where there's been an agreement to arbitrate, that's a really important question. The Supreme Court of Minnesota recognizes that, but they say, look, parties are free to choose whether an arbitrator decides everything, including fraud, or whether they only decide some issues. And in order to ascertain that, we need to find out what the party's intent was. And to find out the party's intent, we look to the language of the agreement. And here, at the bottom of page 927, the court, Minnesota Supreme Court, quotes the arbitration provision, the specific one that was applicable in this case, which says that any controversy or claim arising out of or relating to this agreement, and then it says, or the making, performance, or interpretation thereof shall be settled by arbitration. Since this clause talks about the making of the contract being subject to arbitration, the court feels that sweeps up in its scope the question of whether there was fraud in the inducement, and so everything really needs to be decided by the arbitrator. The court cites a policy consideration too, which I think is kind of telling about maybe modern attitudes of courts toward arbitration. If it was once hostile, if courts were once hostile to the idea of arbitration, as apparently Congress thought they were in 1925, Now I think the pendulum has swung quite the other direction, and the court on page 928 in section 2 of its opinion says, look, we're concerned about how arbitration agreements are going to be enforced if a party can just back out of the arbitration agreement and get into court by alleging fraud in the inducement. And we don't think that's a good policy decision, and we think there should be very particular, compelling reasons to take it out of arbitration, and the party needs to plead that with particularity. There's a rule of civil procedure when you take civil procedure that fraud needs to be pled with particularity. The court is sort of lifting that up and saying, don't just plead fraud to get into court, to get out of an arbitration agreement. You're going to need to be very specific, and you're going to need to have a different arbitration clause that makes more clear that the questions of fraud and the inducement and things like that would be decided by a court. On page 929, in the first note after this case, the authors of our text tell us that Minnesota has adopted a version of the Uniform Arbitration Act. And so this matters as well. Most states, including Tennessee, have adopted some type of arbitration act, just like the federal government has enacted a federal arbitration act. So that if you're in state court and having a struggle of this nature with whether something is arbitrable or not, that's going to be affected by the language of your state arbitration act. And so the interplay of the state act, the federal act, and the language of the contract, those three things are what's going to need to be thought about if you're a lawyer facing a question of whether a court would compel arbitration or not. I mean, again, typically the party that asked for the arbitration clause wants any dispute to be decided by the arbitrators. The other party probably prefers the courts to decide it. So that tug of war, that tension is what one of the things that we're talking about. So I'm going to move on. Well, let me back up. There's another thing I wanted to lift up in the notes, and that's in note B on page 930 in your materials, and that is that if there is a direct attack on the agreement to arbitrate, then that maybe perhaps can be argued should be decided by a court. An attack on the enforceability of an arbitration clause should not be submitted to the arbitration unless the parties have clearly agreed. That's some authority. There's authority going the other way, I think. And again, I think the thing maybe for you all to take away is that this tension between whether something can be forced into arbitration or whether it can be forced or allowed in court for a judge to decide is an important battleground at the beginning of a lot of contract disputes where there is an arbitration clause. If a party can successfully attack the arbitration clause itself, that may be a way to get a court to decide it in some instances. So let's talk about the Stolt-Nielsen case a little bit. So this is another sort of building block in the series of cases that the Supreme Court has decided concerning arbitration. And this sort of sets the theme for what the rest of the time we will talk about when we think about arbitration clauses. And that really has to do with whether there can be class arbitration and how class arbitration when it might be allowed, when it would not be allowed. Class actions in our country are governed by Rule 23 of the Federal Rules of Civil Procedure. In our state, in Tennessee, we have a similar counterpart, Rule 23 of the Tennessee Rules of Civil Procedure, that generally allow, in some instances, cases to be brought on behalf of an entire class of people rather than just on behalf of one individual plaintiff. We've touched on this, I think, in the class before a little bit. And if you pause to think about that, this is also a pretty important, powerful, and sometimes controversial tool that's available in the American system of civil law. It's worth pointing out that class actions are not available in all countries. France, for example, at least the last time I looked at this, France did not have a comparable vehicle for adjudicating things on behalf of an entire class. And let's pause for a minute, and before we talk about Stolt-Nielsen, talk about why people might want to bring things as a class action. And one of the classic requirements of a class action is that you have a lot of people, numerosity, a lot of people who are subject to the same type of problem, whether it be an overcharge, whether it be an antitrust violation, whether it be a statutory violation of some kind, that a lot of people have common, they're numerous people and their claims are common, that they arise in the same fact pattern. So this could be where there are multiple contracts that are identical with lots of people, consumer contexts, things of that nature. And it's a fact, and you all have all seen this if you've opened a brokerage account and read your brokerage agreement, I'm certain, includes an arbitration provision. And this is so that I think generally the industry, the financial and securities industry, does not want to have a lot of in-court disputes about its services and about the way that it handles investors' funds. And so they require arbitration in a lot of instances. Again, that's a way, if you think about sort of the power to contract, that's a way that industry can keep disputes private and confidential, keep them out of the public records. They can perhaps resolve the cases more expeditiously and cheaper, and they can probably, in a lot of instances, pay less than what they would be subject to paying if a jury decided what the damages were. At least that's the belief. So there are widespread swaths of industry where the party with the greater bargaining power, the superior economic power, will put an arbitration clause in a provision for those reasons and perhaps for other reasons. In Stolt-Nielsen, you had a contract that met some of those qualifications. That is that the kinds of services which were tanker services, parcel tankers, and the same kinds of provisions were repeated for lots of users of those services, charterers, like animal feeds, and that was the party here who was subject to such an agreement and who wanted to challenge aspects of that agreement. There was an arbitration provision, and the question is whether the party complaining here, animal feeds, could bring that on behalf of itself but also on behalf of others similarly situated. That is to say, whether there could be a class arbitration. That had apparently not been addressed before, not decided, and it's interesting to note how recent we're talking about, 2010, so just barely 10 years ago, not even 10 years ago. And the question really became, the agreement in that instance, the court says, was silent, in parentheses, in quotation marks, silent on the question of whether an arbitration could proceed as a class action or whether it had to proceed case by case individually. Now, I'm sure you can see that if you're the party being sued, you don't want it to be a class action. You want to make every individual plaintiff go through the hoops of proving its case individually. That there's a certain discouragement of bringing proceedings that way, particularly if the claims don't involve a lot of money. If it's a class action, there can be aggregation of claims, and they might be a big number, like we saw in the cell phone termination cases a couple of weeks ago. They can add into the millions, tens of millions, and more dollars, and it's well worth a plaintiff's lawyer taking on representation of those folks as a class, whereas it might not be very worthwhile for a lawyer to take on individual claims one at a time. The Federal Arbitration Act, again passed in 1925, doesn't say whether there can be class arbitrations or not. And so here the court is called upon to decide, does this arbitration clause, which is silent on the question of class arbitration, does it allow class arbitration to proceed or does it not? Now, the majority of the court, and again, there's a sharp dissent, which we'll talk about, but this case went up and down in the system with folks reaching different conclusions. The arbitration panel concluded that in the absence of a prohibition of class certification, the matter could proceed as a class arbitration. Again, that would have significant consequences for the defendant and the plaintiffs, but it would certainly give the plaintiffs a big advantage if it could proceed as a class arbitration. And here Justice Alito goes through some history of the act and says, look, we can't decide whether that's a better policy to allow class arbitration. We don't think that the arbitration panel should have decided what is the best policy. We need to look at the statute itself and, as a matter of strict, rigorous statutory construction, decide whether Congress intended to allow class arbitration when a clause is silent. The majority here thinks that thinks that the intent of Congress was not to allow class arbitration. They rest their reasoning, at least as best I can tell, largely on the idea that arbitration is a matter of consent, not coercion, as they call it, that the parties needed to have consented to arbitration, and that when they consent with a clause that doesn't say one way or the other, they are consenting only to arbitrate the particular contract in question for the particular parties involved at that instance. And so they sort of really rest on the consensual nature of what arbitration is all about, and essentially feel like the Federal Arbitration Act embodies that policy of consent, and because of that, the court's going to conclude and does conclude that that in the absence of an agreement that's expressly permitting class arbitration will not be permitted. Now, that's a pretty powerful decision, particularly in an era where arbitration clauses are becoming more and more and more common, and in a lot of industries, more and more and more prevalent. What this suggests, I think, is that, and the court has a lot of language in here about the disadvantages of class action and the complexities of class actions. I think there is a judicial skepticism, it would not be too strong to say, a judicial skepticism of class actions, that they are abused by plaintiffs' lawyers, that they are a tool to gouge settlements from big companies when it's not necessarily justified, and that folks will pay simply to get rid of the class action, and that it doesn't provide a lot of individual benefits to class members. Those are criticisms of class actions in general. In my mind, they don't answer the question of whether arbitration should be allowed to go forward as a class or not. And you all can see that there is a pretty strong dissent written by Justice Ginsburg, with Stevens and Breyer joining in. It's pretty easy to spot the patterns here of how the members of the Supreme Court are lining up on these arbitration issues. And these more liberal justices would say that the court is basically being premature. They should not decide whether class actions are always allowed or never allowed. what the notes after the case tell you is that essentially what the court has done in the Stolt-Nielsen case is come up with a default construction of arbitration clauses. That is to say, if a clause is an arbitration clause and it says the parties will arbitrate their dispute, if it is silent, it will not allow class arbitration. Now, think about what that means. That means that when clauses are drafted and they don't specifically address the question of class arbitration won't be allowed. It's a default, and the material tells you that defaults tend to stick. The materials pose the sort of rhetorical question, and I'm on page 929 in the first paragraph here. If there is a social interest in permitting the aggregation of claims, we might want the default to be that class arbitration is permitted. We might. But at this point, the Supreme Court has decided that the right to have class arbitration is not present if the clause is silent. Again, interpreting the Federal Arbitration Act in a way that I would suggest is favorable to parties wanting arbitration clauses so that they can basically tamp down the ability of plaintiffs to bring class actions. And the next couple of cases we talk about are really going to drive that point home, and that'll be where we quit for the night talking about arbitration. On the bottom of page 939, the authors of our text point us back to the Misty Ferguson and Countrywide Credit case. And you all will remember that this is an unconscionability case we discussed when we were talking about the unconscionability doctrine in general and how it often applies in consumer contexts. And here it was used by Countrywide, or it was used on behalf of Misty Ferguson against Countrywide because Countrywide had an arbitration provision for all employment contracts that tilted the arbitration playing field very heavily in favor of the company and against the employee. And you all can go back and remind yourselves of that case, but it was things like how the discovery was done, how the filing fees were paid, how many experts could be used. All of those sort of ground rules were spelled out in the agreement to arbitrate, and they were spelled out in a way that the court felt was heavily tilted in favor of the employer and was therefore unconscionable. So the Countrywide case stands for the notion that an ordinary principle of contract law, that is the doctrine of unconscionability, can basically say that an agreement to arbitrate is unconscionable, and the agreement can't be severed, the court said in that case. You can't take some of its parts and still enforce them because it was also interwoven, and the court refused to enforce arbitration and held that the arbitration provision was unconscionable. So pause there. That's a state court, and this gets into some federalism questions that are raised by these Supreme Court cases we're talking about, that a state could use its unconscionability doctrine to refuse to enforce an arbitration clause, even though arbitration might generally be a favorable thing, favored by the courts, encouraged by the courts even, but not where it's unconscionable. The same would be true, I would suggest, if a clause were fraudulent, if a clause had been obtained by duress. Those kinds of things would vitiate the existence of a contract, and the Misty Fergusons of the world would be able to litigate their employment disputes in court. Again, remember, the employee in that case, Misty Ferguson, wanted her case to be in court. Countrywide wanted to force it into arbitration. I think they were just a little bit too greedy in the way they drafted their arbitration clause, favoring the employer so much that the court throws it out as unconscionable. All right, so that leads us to our last case to talk about, and that's the AT&T Mobility case. Now we're in 2011, and you can see we've had cases from 08, from 10, and from 11. This is the last one we'll really spend any time on. dealing with arbitration provisions and the attitude that the United States Supreme Court has towards arbitration provisions. The Countrywide case, the Misty Ferguson case, should teach us that these are clauses favored by the powerful, favored by those with a lot of bargaining power, and disfavored by those who would rather get in front of a jury with their claim, and disfavored by those who would rather have a class action to bring their claims. So AT&T Mobility is brought by some individuals who bought a telephone from AT&T or got a telephone, signed up for a contract with AT&T that included a free phone. That's how it was advertised, a free phone. The arbitration provision in the fine print of the agreement specifically said in that case, and I'm on the first paragraph of page 940, that the claims would have to be brought individually and not as a plaintiff or class member in any purported class or representative proceeding. In other words, there was a waiver of class action proceeding in this arbitration agreement. So on its face, it says you can't, if you have a claim, you can't bring it as a class. This isn't a standard agreement that's between a consumer and a pretty powerful company, AT&T Mobility. And the folks who drafted this contract on behalf of AT&T, I would suggest the lawyers were good lawyers. They were careful. Because unlike the Countrywide case, the Misty Ferguson case that we've referred to, in the second paragraph of Justice Scalia's opinion, he is able to go through the provisions of this particular contract and point out favorable things for the individual consumer, such as a streamlined process for bringing a claim, a process for settling, a process for paying attorney's fees, for paying double if they didn't get in an arbitration at least what was offered in settlement. So there were protections of a sort built in for the consumer in this arbitration agreement. If anything, Justice Scalia thinks anyway, this was tilted on an individual basis in favor of the individual consumer. That is, if the consumer has a mechanism for getting some redress, suggests Justice Scalia. The plaintiffs in this instance objected to the fact that they were charged a sales tax, $30 sales tax, even though the phone was advertised as free, and they purported to bring that claim on behalf of a class, and we know from the cell phone termination cases we discussed, $30 multiplied times millions probably of customers for AT&T could be a really enormous number of damages if the damages are awardable. AT&T moves to compel arbitration of the dispute pursuant to the clause that they have that says you have to arbitrate, and furthermore, you can't have a class arbitration. And the district court apparently comments fairly favorably on the provisions of the arbitration agreement that give the consumer some relief, but says, look, in California, they have a case and a policy that says waivers of arbitration, of class arbitration in consumer contracts are unconscionable. Let me say that again. Waivers of class arbitration in consumer contracts are unconscionable. Now, again, we know that unconscionability is a general doctrine of contract law. We have studied it. We know that it applies to consumer contracts far more frequently than it would to contracts between merchants or commercial entities. And this is a consumer contract. It's a contract of adhesion. Justice Scalia agrees that it's a contract of adhesion, but he's going to reach a result that says the Federal Arbitration Act preempts state law in this area. and provides basically prohibits a state from using its unconscionability laws to allow class arbitrations. It's a remarkable opinion. It's an opinion that he tries to ground on the language of the Federal Arbitration Act itself and the intent of the Federal Arbitration Act. But it's a case that presents serious federalism questions. So one sort of interest that's present here is California's interest in not enforcing unconscionable contracts. The state of California has a doctrine that it calls the Discover Bank Rule. And the Discover Bank Rule says don't enforce class waivers in consumer contracts. They are unconscionable. That's the interest of the California court. That's California as a state having that interest. Scalia butts that up against the interest of the federal government in passing the Federal Arbitration Act and having a policy that's nationwide in favor of arbitrating disputes, but against having class actions in arbitrations. And that again stems partly from the Stolt-Nielsen decision in 2008 that we have just talked about. And that judicial antagonism towards class arbitrations, Scalia opines, is in conflict with California's desire to limit by unconscionability the waiver of class arbitrations. So those policies are in conflict. How does the court decide? The court says on page 943, California's Discover Bank Rule interferes with arbitration. Interferes with arbitration. Now, the statute itself says that arbitration is to be placed on the same footing as all contracts. And Scalia believes that the Discover Bank Rule singles out arbitration agreements for some type of disfavored treatment by California. And so he says, look, if California tries to do that, it's violating the Federal Arbitration Act. The Federal Arbitration Act preempts state law in this area. Now, the notion of federal preemption is one that you'll have to study when you take constitutional law, but it basically would say that when there's federal legislation in an area, if it's valid federal legislation, it's going to be the exclusive rule, or it's going to trump state law. That's what the preemption notion is all about. Scalia believes that the Discover Bank Rule is one that should be ignored by the federal courts, basically, held invalid under the Federal Arbitration Act. And just pause for a minute to think about the consequences now of what we've got. Under Stolt-Nielsen, we have a decision that says if an arbitration agreement is silent as to whether there can be a class arbitration, there can't be one. There cannot be a class arbitration. Silence equals prohibition of class arbitration. We then have this decision that's going to say a powerful company that does a lot of consumer contracts and their contracts of adhesion can include a waiver of class arbitration. And that waiver would be upheld as a matter of federal law, regardless of state doctrines of unconscionability. And so you've basically got a recipe, it seems to me, a recipe for those with powerful contracting ability with consumers for something that they all need or want or is very popular, to essentially impose contracts of adhesion that are going to prevent class actions from going forward, because the parties can't go into court. They've agreed to arbitrate, and they can't have a class action in arbitration because the arbitration clause says so. So let that sink in for a minute. In vast areas of the economy, those with the ability to include complex arbitration provisions in their agreements can now impose that regime on consumers, and ordinary doctrines like unconscionability, the court says, can't be used to invalidate those class waivers. That's going to insulate the ATs and Ts of the world from consumer disputes in general. And as the dissent thinks, it's going to lead to lots and lots and lots of claims just simply not being pursued at all. Although the way AT&T drafted this arbitration clause, there might well be an incentive for an individual plaintiff without a lawyer to go and vindicate that individual consumer's complaint. There's no lawyer who's going to go represent a client over a $30 claim, as the dissent correctly, I think, points out. And for those folks who simply don't want to pursue the claim, can't fill out the paperwork, don't even know they have a claim, which is probably the vast, vast majority of customers, those claims are simply never going to be asserted. And assuming that the claim has validity, then valid claims are going to go unredressed. The majority says, too bad, that's okay. That whatever important policy might be to encourage class actions, even if that were a good policy, if it's inconsistent with the Federal Arbitration Act, it's not valid. It doesn't matter what the policy is. The dissent, I think, rests on the notion that unconscionability in validating a waiver of an arbitration clause is really no different from any state using any of the tools of contract avoidance to fail to enforce a clause like that. The dissent even uses the example, if that clause had been obtained by duress, would that be somehow preempted by the Federal Arbitration Act? Somebody holds a gun to somebody's head and says, sign this waiver of arbitration. Under the law of every state, that would be a contract obtained by duress and would not be enforceable. How is duress any different, the dissent asks, from the doctrine of unconscionability? Rather than singling out arbitration for being disfavored, the dissent simply thinks that the California Discover Bank rule uses ordinary principles of contract law in a way consistently with how it uses those principles in all other contexts, and would happen to invalidate this type of waiver that California thinks is unconscionable and against public policy. Well, I think that's probably enough. You can sort of see a little bit more flavor in the American Express and Italian Colors restaurant case on the bottom of page 947. That's an antitrust case where a court does not allow an individual claim to be aggregated with other claims because of a class action waiver. Justice Kagan dissents and basically says the monopolist gets to use its monopoly power to insist on a contract, effectively depriving its victims of all legal recourse. And here is the nutshell version of today's opinion, admirably flaunted rather than camouflaged, too darn bad. Justice Kagan sort of calls out the majority as being antagonistic to Rule 23, that is to say, class actions, and uses federal preemption and the court's interpretation of the Federal Arbitration Act to prevent these claims from being brought as a class. I'm about to wrap up, but just to sort of step back from all this, this is the first time we've had a lot of United States Supreme Court cases on one topic in one class. And it's interesting that the court has weighed in on arbitration the way it has. I think you all can see that whether you agree with it or do not agree with it, it's a split of authority as to how folks view it. But the majority view is that class arbitrations are disfavored. Expanding the scope of review of arbitration decisions is disfavored. And wittingly or unwittingly, the court has given tools to those with a lot of bargaining power to limit their liability to consumers through contracts that include arbitration provisions and include waivers of class arbitrations. So I'll probably come back next Monday and record a lesson on assignment. I may try to do third-party issues that day or another day. Those are the two topics that we have remaining in our syllabus. So everything remaining in the course is really all about third-party issues. Read those materials really carefully. Those will be on the exam almost certainly. They will be on the bar exam almost certainly. And when we get through those and we get further into April, maybe we can see what kind of review, if any, we can have. I miss being with you all in person, and miss you all in the class. I'm lecturing to an empty classroom here, but I do hope I get to see you again in person soon. Thanks a lot. Bye-bye.